It's true. At the supermarket checkout, the girl checking out my food looks at the cart. There's Kevin, there's Jennifer. Hey, they're both yours? Oh, nice kids, a boy and a girl. Quote, are you done? Now, I don't know what to say at those moments. I'm much happier when you have a very large family. I think once you get past 5, which is the tipping point, you have 6, 7, 8 kids, people realize that you're just too far gone, you're beyond recall. You're obviously playing by a special set of rules. So there really is 2 kinds of reactions if you're announcing a pregnancy and somebody says, is you first? You say, no, it's my 7th, or our 7th. There's 2 things they do. One group of people starts gasping and convulsing. And finally, the words find their way through their lips, something like, oh my God, your poor wife. Or they say nothing, and they stare at you blankly, uncomprehendingly. It has the look in their eyes I would compare to the look in the eyes of a cow, only one that's been lobotomized. But in our case, at least, the great scare occurred when we had our 5th child, where Pam was pregnant with our 5th, who became, or is, Michael Bradley. The time we were living in Champaign, Illinois, I taught U of I for a while, and we had a visitor, another actually pro-life activist whom you may have heard of or read about, an academic named Hadley Arcus, a terrific speaker, a great writer. Well, he was visiting and connected with a conference, and he was over, and we're expecting, it's our 5th Hadley. Now, for some reasons that still escape me, Hadley decided it was important to share with my wife and I the following factoid. Hadley says, you know, every 5th child born in the world is a Chinese communist. Now, my topic today is not humor, but pro-life legislation. And I mean to talk about legislation, not laws. And the difference really is that I'm talking about pending bills. They're not enacted. They're not laws yet. And I have in mind 3 specific pieces of legislation, all pending at the federal level, that is in Congress. And all they're all pro-life bills, but they all have the following characteristic in common. They are all bills that have passed the House of Representatives, and will surely be signed by President Bush should they ever pass the Senate, but are presently stalled in the Senate. The prospects there are uncertain. My observation from a distance is that the Senate leadership is sitting on these bills and would prefer that they not come up for a vote for fear that they would pass. But the 3 bills are the Born Alive Infants Protection Act, which is a federal ban on infanticide, the Unborn Victims of Violence Act, which is a federal ban on feticide, or killing an unborn child, and the Human Cloning Prohibition Act, which prohibits cloning. Now, I leave aside one area of possible pro-life legislation, an area that may see a bill introduced during this Congress. I think not, but I could be wrong. It's a matter of partial birth abortion. 2 federal bans on partial birth abortion passed both houses of Congress during the Clinton administration, but each was vetoed by the president. And in each case, there simply weren't enough votes to get the veto overridden in the Congress, not enough votes in the Senate. So it looks like the present Senate is no more disposed to override the presidential veto, though in this administration there wouldn't be a veto to override. Besides the problem in the Senate, there is a Supreme Court decision of the year 2000 called Stenberg v. Carhart, which the court struck down a Nebraska law against partial birth abortion. And, well, some of the technicalities still escape me, but it's fair to say that in general there's a very narrow opportunity, if there's any opportunity at all, for an effective, that is constitutionally valid ban on partial birth abortion to be written and to get past the Supreme Court. Now, it's true that many otherwise pro-choice or pro-abortion legislators are against partial birth abortion and would vote to ban it. Now, in the words of my congressman in Indiana and South Bend, Tim Romer, who is pro-life, he's described it as a gruesome, brutal, and grisly procedure that is only inches from infanticide. That's partial birth abortion. Well, the first of the 3 federal bills I wish to discuss is a ban on infanticide. It's called the Born Alive Infants Protection Act, and it was passed by the House on April 13th of 2001 by a lopsided vote of 380 to 15. No action has been taken yet in the Senate. For the numbers in the House, you can imagine that actually if the bill comes to the floor and is voted upon, there's no way it can fail to pass. It's simply difficult these days, even in a culture of death, to be pro-infanticide. So the Senate leadership, I think, wishes to bottle up the bill to prevent that vote from taking place. Now, a little more technically, what does this actually do? What does this bill actually say? It basically bans infanticide insofar as the federal government can ban infanticide by saying that wherever the words person, human being, child, or individual appears in any federal law, those words are to be understood to include, quote, every infant member of the species Homo sapiens who is born alive at any stage of development. Now it goes on to define born alive as, at least in part, the complete expulsion or extraction from its mother of that individual, whether the umbilical cord has been cut, and regardless of whether the expulsion or extraction occurs as a result of natural or induced labor, cesarean section, or induced abortion. Now that's what the bill, that last one is really what the bill is probably after. It's after the very limited, but still real, practice of survivors of induced or procured abortions being left to die. I don't know that they're euthanized, but rather kids, infants are abandoned on occasion, where an induced abortion fails to accomplish the desired result. And the testimony, or one of the hearings on this bill in the House a couple of years ago, or a year ago, it was very chilling testimony by a nurse who works in a hospital near Chicago. I forget the name of it, but the woman's name I think is Jill Stanek, who worked as an OBGYN nurse or delivery room nurse and observed at least a couple of instances where children marked for death, that is, for abortion, survived the abortion intact and were abandoned to die in or around the delivery room. Well, this is really what the bill is after, protecting survivors of procured abortions. Now, there were some objections to this bill expressed during hearings, although, as I noted earlier, there were very, very few votes ultimately registered against it. One, it's difficult to describe this objection. It was an attempted objection. I happened to attend the hearing and saw this attempt made. One member of the Judiciary Committee of the House of Representatives was, I think there were words struggling to pass her lips and find their way into the conversation. But I think she was a victim of not having read the prepared remarks, or the remarks prepared for her by staff, because she was actually unable to say what she meant. She was trying to say that something called the hydidiform mole phenomenon would somehow gum up this legislation. And the short of it was that her idea was that there's a kind of human individual of sorts, hydidiform mole, which occasionally succeeds in being born. But would this bill require that the hydidiform mole be treated as a person? And that's in substance what she was trying to say. The answer was no. That a hydidiform mole, as I understood the answer, and I think this is correct, is really not a human individual. It's a kind of failed attempt, a naturally bungled attempt at human reproduction. So it's not a case of a sort of human being born. So that was one attempted objection. There were two other objections. One was a wild roundhouse punch that somehow this was against the spirit, if not the letter, of Roe versus Wade and the other abortion rights cases. Well, maybe, but only if abortion rights amount to a right to a dead child as opposed to a right to terminate a pregnancy. And there you had really the second, you might say, of the aims of the legislation. One, to protect the survivor of procured abortion. Two, to establish, perhaps almost conclusively, that abortion just means terminating a pregnancy. It doesn't mean terminating a child. So that was the answer. And that was kind of the bait that almost no one rose to. That is to say, if Roe was thought to mean a dead child, that is infanticide, well then Roe means something that really a large number of people would then become alarmed about. The third objection was a little more serious. It was that the bill, by establishing, you might say, the personhood of the newly born infant, somehow would require parents, let's say in cases not of abortion, but of natural births of debilitated kids or kids with problems, that somehow the parents would be required to, in no technical sense, do whatever was medically possible for that kid, to engage in all extraordinary means available, or take all extraordinary means available to keep that kid alive. And that's not true. I mean, it's a perhaps plausible reading of the bill, although I don't think so. But the fact is, this bill does not require a particular regimen of treatment for anybody. It really just establishes, you might say, the equality of everybody once they're born. And whatever treatment is appropriate in the parent's judgment for a newborn, well, that's the standard that would be applied, you might say, on an equal basis to every kid who's born. Put that a little bit differently, whatever passes muster in our legal system as proper parental decision making, that is, parents making a choice among the range of options for a debilitated newborn, they're not allowed to do anything that results in homicide. They can't kill these kids. Well, but there's still a range of options that they can choose from among, and they're not required to choose any one of them over another by virtue of this bill. So while plausible, perhaps, this idea that there was an equality argument in favor of extraordinary treatment for all newborns simply wasn't quite right. Now, in the end, what carried the day was the common sense of it. One member of the Judiciary Committee, a Manhattan congressman named Gerard, described himself, with abundant reason, by the way, as the most pro-choice person on the face of the earth. But Nagler said at the hearing, I don't understand what the opposition to this is about, because once you're born, you're not a fetus, you're a baby. And that seemed to carry the day with all but 15 members of the House of Representatives. The second bill, the Unborn Victims of Violence Act, feticide. I should say, just to back up a little bit, on the state level, I'm talking about federal legislation, on the state level, protection of newborns is accomplished not by writing new laws such as this one I was just talking about, but rather all the existing homicide laws in every state, Illinois, Indiana, New York, where I was a prosecutor. They all will say that homicide of various sorts consists of taking, unlawfully causing the death of another person. Now, in states, applying the term person to the victim of a homicide requires the prosecutor in every case, I mean, implicitly, perhaps even unconsciously, because it's obvious most times, but every time there's a homicide prosecution, the prosecutor is deciding that the individual who died was a person, because murder can only occur, homicide only occurs when another person is killed. And in the states, not in the federal government, but in the states, what happens is, by virtue of applying ordinary homicide laws, newly born infants are protected from the depredations of those who would abandon that infant or kill it. Feticide, this bill, there are about 27 or 28 feticide laws in the states. I think 27 or 28 states have feticide laws protecting the unborn child, the fetus, in utero. This federal law basically works as follows. The federal ban, which is called the Unborn Victims of Violence Act, basically says whenever somebody commits a federal crime, which is already on the books, let's just say assaulting a member of Congress, and to make this work, let's say assaulting a female member of Congress, if during that crime the unborn child of that victim, the female member of Congress, is harmed or killed, there is, in the language of the statute, a separate offense under this section, a separate count or an additional count, a second victim. That's what it amounts to saying. Whenever an unborn child is harmed or killed in the course of harming or killing its mother, there's a separate offense because a second victim under this statute. The person, the perpetrator, as the police say, the perp, need not know the individual, the woman is pregnant, need not intend any harm to the unborn child. It could just, for whatever reason, be an attack upon the female member of Congress by someone who doesn't even know she's pregnant. If it is the case, however, it can be proved that the attacker intentionally attacked the unborn child or intentionally killed the unborn child, there's a separate murder count. Two victims, or at least an additional murder count for the unborn child who's killed. This is what's meant by feticide. Okay, objections. At the hearings on this bill, One objection was, I'm going to just describe and leave as technical in nature, about the wisdom, soundness, or validity under criminal law principles of what is called, in this area among the cognoscenti, transferred intent. If someone attacks a woman not knowing she's pregnant, is it somehow fair and in accord with time-tested principles of criminal responsibility to hold them responsible for, in a sense, doing what they didn't even know they were doing? Now, it's an unusual situation, but not unique, and I think it is fair. It kind of is like something in the criminal law called felony murder. Enough said about that. Now here, there was a kind of an opposing stance articulated. This gives you a better sense of what the bill is really about. The opponents of the bill, the federal feticide law, said, well, sure, something's happening when this female member of Congress is attacked, and where she's pregnant, and where her, they would say, fetus, is harmed. Yes, something in addition to a simple assault has occurred. But their position was that that additional factor, the unborn child, should be taken account of by enhancing the punishment of the person who attacked a female member of Congress. It would be, you would call it more an aggravated assault upon her, not a separate victim, not a separate count. But if you attack a female member of Congress, you get, let's just make it simple, 10 years. If you attack a female member of Congress who's pregnant and you hurt the unborn child, it's 15 years. Now the advantage of this is not because it somehow reduces the liability of the attacker, with whom no one had any real sympathy, but rather it makes the injury to the unborn not an injury to a second person or victim. Rather, it's a kind of additional injury to the interests of the mother. Now that, the pro-choice opponents of this bill are quite ready to say, that they're quite happy to say, a pregnant woman has a kind of interest, a liberty interest or whatever, in the integrity of her body and in her unborn child. And if someone comes along who's not acting in her direction, that is an abortionist, but if someone else comes along and attacks that child, she has been injured in an extraordinary way. And they have no problem with that. What they objected to and wanted to stop was the recognition, you might say, of the unborn child as an independent, separate victim. Because that would imply, in a sense, that there's a separate person there. And that they don't want. Now that was really the basis of the sustained attack upon the federal feticide law. And it deserves a little bit more of a careful look. And the attack was something like this. The objection to the federal feticide law, separate count, separate offense, separate victim in a feticide attack, or an attack on a congresswoman. The objection was that by protecting unborn children in this way, pretty much the way other persons are protected against being attacked, that this was somehow inconsistent with Roe versus Wade, which is the great case, the infamous case from '73, and the cases following it. The objection continues, is there no difference between this act and an act that flatly said, well, the unborn are persons? And is that not inconsistent with Roe versus Wade and the cases following it? So question, isn't it inconsistent with Roe versus Wade for Congress to say something that's tantamount to the unborn are persons? You kill them, you're a murderer. And you go to jail for as long as you would go to jail for killing anybody else. That was the objection. Now the answer to this objection would very likely, I think, have to have been a concession. Yes, that's right. If the Supreme Court in Roe versus Wade, or in some other case, had ever held that the unborn are not persons. The Supreme Court has never held that the unborn are not persons. In fact, the Roe versus Wade court said that it did not, quote, need to resolve the difficult question of when life begins, end quote. The Roe court said, in addition, that the, quote, judiciary is not in a position to speculate as to the answer to that question. In no general or broad way, implicitly or explicitly, did the Supreme Court hold that the states or Congress would be unable or under a disability when it came to the matter of defining persons. All the court held in Roe, and it's not a small thing, but in this context it's appropriate to say all the court held in Roe, was that, in that case Texas, but by extension Congress and all the other states, could not override the rights of pregnant women by defining the unborn as persons. And that meant, in context, override the rights of women to secure an abortion if she wanted one. This understanding of Roe I describe as the following: as against the whole world, save for the woman and people who are cooperating with her in giving her or procuring for her an abortion. As against the whole world, but the woman, the pregnant woman, and the abortionist. The government in this country is free to define the unborn as persons, against the whole world and across the board if they choose. That means so long as that woman does remain free to secure an abortion if that's what she wants to do. This understanding of Roe was explicitly confirmed by the Supreme Court in the 1989 case in Webster, the Webster case. There, the state of Missouri had legislated that the life of each human being begins at conception, and said further that unborn children have protectable interests in life, health, and well-being. In short, Missouri said, look, the unborn are persons. The Eighth Circuit Court of Appeals said, this is inconsistent with Roe. The Supreme Court reversed the Eighth Circuit. The Supreme Court said in Webster, of its own prior decisions, including Roe versus Wade, that Roe meant only a state could not justify an abortion regulation, otherwise invalid under Roe, under the ground that, that's where the quote ends, the unborn are persons. So to put it differently again, the Supreme Court of Webster is saying, look, as long as we're not talking about abortion, states are free to say and act as if the unborn are persons. Now, this Unborn Victims of Violence Act passed the House in April of 2001, 252 to 172. As far as I know, no vote is scheduled on this one either in the Senate. Finally, cloning. You heard a great deal about cloning, or at least some earlier this morning from Dr. Elstein. If you want to know more about the basic setup of cloning and even what's happening in Congress, you probably could just turn the news on tonight because the hearings are imminent. Sometime this week, I think there'll be some hearings. Just to clarify the situation, there are two bills. Both are called something close to cloning prohibition. So for information purposes, and this really does just echo something that Dr. Elstein said, the good bill in the House is authored by Weldon. In the Senate, the sponsor is Brownback. The bad bill in the House was authored by Greenwood. The bad bill in the Senate, I think, is sponsored by Feinstein and Tom Harkin. The difference is, I'm going to take it in this most straightforward way, the Greenwood bill, Feinstein bill, would ban reproductive cloning. The language of that statute basically defines cloning in a more technical way, and then says you can't do cloning with the intent to initiate a pregnancy. So that's the more careful or exact language that indicates what's being banned is so-called reproductive cloning. Cloning with the intent to initiate a pregnancy. Now, the alternative is a kind of outright ban, insofar as the federal government can outright ban anything, and that's the Weldon bill. Again, defines cloning, and then through a kind of convoluted set of instructions, owing for constitutional reasons which aren't all that interesting even to me, and I teach the stuff. Basically, it amounts to a total ban on cloning, although there is technical language that may leave slight gaps in the coverage of the ban. But those are the two different bills. Further, the arguments against it, the arguments in the main are against an outright ban or a total ban because of the benefits promised of therapeutic treatments, which will be acquired or obtained only by developing clones sufficient to do research and eventually using a large number of clones to provide regimens or treatments for people with Alzheimer's, etc. There were a couple of sort of constitutional points in dispute, so I just want to mention those to cover the matter not from a policy perspective, which Rich Dorflinger can and probably will do much better than I could in a few minutes. From a constitutional point of view, there were a couple of points raised in opposition to a flat-out ban on cloning. One of them was that somehow there's a right, I suppose, of scientists to freedom of research and inquiry that would somehow be short-circuited, cut off by an outright ban. And I think the answer to that is that, well, that sounds like it could be true. maybe ought to be true in some general way. Actually, there isn't any real constitutional basis for that position. There really just isn't a general right of constitutionally based scientific inquiry. There may be elements of it here and there, but there really isn't anything of a general nature. Now, it's true that both of these bills would ban so-called reproductive cloning. So it's not quite time to wonder if there might be a kind of constitutional argument to the effect people have a right to reproduce via cloning. There may be a need or a market for that argument someday when reproductive cloning itself becomes more technically feasible, safer, less morally repugnant, and therefore something people want to do. You may hear it first, I don't think there is such an argument. Why not? I don't think, despite Roe versus Wade and other quite broad holdings in favor of what could be called autonomy with regard to reproduction, there are cases that certainly need to be described as reproductive rights cases. There actually isn't something in the cases that amounts to a right to have children. It may sound like that, but it really isn't that. What there is authority for in constitutional law is something that's two things that are really related but quite different. One is that there is some authority for a measure of sexual freedom, to have sex without reproducing or to have sex while trying to have a child. That's true. And there is very specific authority for abortion, which has to do with terminating a pregnancy. It is not being made to have a child when you don't want to have that child and you're pregnant. Now those two things are very different really from a right to have a child. There's no real authority for that right. And I don't think that at least the present Supreme Court would be eager to find such a right. Now an aside, my final point, am I done, Paul? Okay. An aside about the constitutionality of cloning. Let's just imagine in a few years we're looking at a world which somehow desires reproductive cloning. The closest in thing, if I were the advocate for that point of view and wanted to make a constitutional argument in favor of cloning, reproductive cloning, I think I'd resort to IVF, not literally, but figuratively, or at least rhetorically. I'd say, look, people, I would assert that people have a right to use IVF, which is indeed, asexual, out-of-body reproduction. And then the embryos which result in a petri dish are implanted in women, and they're carried to term, and then people have babies. And there are those similarities, at least maybe there are some more, between IVF and cloning. I mean, they are both asexual means of fertilization or conception, and then an embryo, baby, fetus is carried to term in the normal way. Now, two things about that. One, although, frankly, its moral acceptability and perhaps even its constitutionality is very widely assumed. As far as I know, and I researched this recently a few months ago, there is no case that says people have a right to IVF. Now note well, I don't dispute that it seems to be taken for granted as an element of our culture, as an option for infertile couples, and there are cases which have to do with IVF, but those are cases, at least the issue in those cases has to do with disposing of embryos frozen, left over from IVF, now that the marriage has broken up. So there'll be a discussion about whether now the mother, who's now divorced from the father and married to another, may sort of unilaterally take hold of those, or the husband has died, may she take hold unilaterally of these frozen embryos. Now I think in those cases the legality, at least, of IVF is taken for granted, but I don't think there's a case that says people have a constitutional right to IVF, and they shouldn't. They don't have a right, at least implied by Roe or any other case I'm aware of, to sort of make a baby, to have a child. And I fear, and my last point truly is, I was talking to Mo earlier, that I fear that even the church here has missed an opportunity. That is to say, over whatever time in the past 10 years or so, let's say it's 10 years ago, that IVF became practically feasible and became something that more and more couples were turning to. So it wasn't something that was done just by weirdos in Bermuda or someplace, but it was something that a limited number of people, but more than a few, would take advantage of. I think the church failed to oppose it, not only from the pulpit, so the Catholics would have known that it's something you shouldn't do, but I think it was an almost total failure to object to it publicly. to make the argument that it amounts or is perilously close to making or manufacturing kids. And a decent society just doesn't do that. I say that the church should have, in my opinion, spoken up and said, this is not only something that's sort of wrong for Catholics as a matter of conscience, although it is, but that a society which cares about the equality of all people and the fact that it's a denial of equality for some persons to come to be as objects or commodities. I think the church missed an opportunity to try to at least educate the culture that this was something that ought not to be permitted at all.
Thank you very much.
The people who were promoting the bill, who were opposed to infanticide, and some of those people said, look, this is not a fantastic possibility. There really is this philosopher with a chair at Princeton who proposes that parents have proprietary rights over children even after they're born. And that was one of the kind of the evils that the legislation was aimed at. But perhaps that really was secondary to the testimony offered by the nurse, whose name was Jill Stanek, about what she saw happen after the procured abortions at Christ Hospital near here. It was nearby. Let me get somebody else. Bill May?
I think you're mistaken about the magisterium. After all, Pius XII, back in the 1950s, was condemning artificial insemination and IVF, even before it became a possibility, and warning states about it. And then, of course, Notre in 1987 certainly had civil legislation in mind. Part of the doctrine was devoted to that. So I thought there was an effort by the magisterium to make it public the dangers of these ways of generating human life.
Well, Dr. May is chastising me and proving to everybody's satisfaction that I'm hopelessly mistaken. And he's quite right. Bill is remarking upon several statements by the papal magisterium identifying various kinds of out-of-body conception and condemning them. And Donum Vitae in 86 or 87 is one good example. I should say that's quite right. What I had in mind, though I didn't say, was the lack of sufficient vigor in the way the American bishops prosecuted that case in our own public square. So perhaps you'll agree with me on that there wasn't noticeable activity by the American bishops, or even organized lay apostolates working with or for the bishops. I think we just missed a vote on that in America. Yes, way in the back, Father? Is that Father? Yeah. Well, basically I agree with you. That is to say, it has to do with Roe versus Wade, its language about personhood. It is true that the Roe court, speaking in this case through Justice Blackmun, for 7 members of the court, said, and I'll just compress it a little bit, that there's a claim on behalf of the unborn made by the state of Texas, that they're persons within the meaning of the 14th Amendment. Now the implication of that would be that the Constitution would effectively require the protection of unborn kids. Put that a little bit differently, this claim would have amounted to making permissive abortion laws unconstitutional, just by force of the Constitution. And it's true that the court said, in these words very close to these, the unborn are not persons within the meaning of the Due Process Clause. Now that's all correct. I think, in fact, the court's mistaken to some extent about that, but that is surely the law. Now I'm talking about something a little bit different. It's the power of a state legislature or the Congress to state in legislation that the unborn are to be treated as persons. And I'm saying that there's nothing in Roe that prevents the states or Congress from doing that, so long as they respect the right of a woman who's pregnant to get an abortion. So I agree that it sounds like those two positions are incompatible, but they're not actually. So I agree with you and would simply still stand by what I said.
One more.
Yeah, one more question. Yes, sir.
In terms of dealing with Catholic politicians, sometimes they your position and imposing their conscience upon other people who do not view the fetus in the womb of the mother as being a human being and therefore having human rights. What do you say to those Catholic politicians? How can you divorce your personal ethics from the ethics that you're espousing in terms of your acting or not acting at this particular bill?
Okay, I think everybody heard that question. That's a radio announcer's voice, so good ask. I won't repeat the question. I suspect you all heard it. It's a good question. I'll give you 3 parts of a response. That's all I have time for. One is that I myself wouldn't suggest anybody divorce their, quote, personal ethics, close quote, from anything else. I mean, what's the alternative? I mean, one only has what one believes to be true. Now, if by personal ethics one means somehow what I subjectively believe to be true sort of for me, but I don't even assert is true for anybody else, well, you want to put those aside. You ought not to impose those upon anybody else, but that's not really the basis upon which I think anybody, including Catholics, ought to be thinking about these issues. But if one imagines that one's ethics are only good for oneself, then you shouldn't impose them. But that wouldn't be peculiar to abortion. I mean, presumably that kind of subjectivism would run pretty far and wide, so that you'd wonder how that person legislates at all. But you can only do what you do based on what you believe to be true. Now, on this issue, 2 other points. One, I don't think there's anything in the Church's arguments, in the little I've said along these lines, and what Dr. Lee or Dr. May or any of the other speakers will say today, about the status of unborn human individuals as persons. I don't think there's anything, strictly speaking, Catholic in that. It's just a mistake if politicians think that there is something peculiarly Catholic that is sectarian or in any other way inappropriate for public life in a pluralistic society in the Church's view about who persons are or whether the unborn are persons. I think it's biology, philosophy, and the type of argument that Pat introduced earlier about what is it that people come to be bodily but only come to be personally later, and at that point they acquire some value. These arguments could be false, but I don't think they're sectarian based upon authority of religion or revelation or any other kind of specialized personal non-public knowledge. Finally, I think there is one flaw in the way Catholic politicians tend to think about abortion. You know, you didn't say it, but let me say it, the idea that one is personally opposed but doesn't want to impose something or other in the public square. Now that could be in good faith, but it really is flawed because it kind of focuses upon this idea that somehow, it seems to presuppose that somehow I believe the unborn are persons. I'm a Catholic politician, and I would never have an abortion or encourage anybody to do so, but somehow it's a proper liberty that other people have the liberty to decide for themselves. And that somehow this is not a denial of justice, or somehow avoids questions of justice. Now I think that's just plain false for this reason. Whatever else you think about pro-choice, pro-life, personally opposed, or anything else, the will to favor permissive abortion laws, okay, wherever you find it, if you favor permissive abortion laws as such, that's your aim, you're in favor, you're pro-choice. You have to will that some set of people, some class of people, the unborn, be withdrawn from the rest of the population, where the rest of the population, me and you and the person next to you, enjoy the equal protection of laws against homicide. To will permissive abortion laws, you have to will that some persons, unborn, yes, but persons, are taken out of that class of protected people. They no longer are entitled to equal protection of laws against homicide and have only the will of their mother, his or her mother, for their protection. Now that move, I do assert, is implicit every time one is in favor of permissive abortion laws, and it's that withdrawal of a class of people from the population, exposing them to private violence, which is itself a denial of equality and just plain wrong.
Thank you.